rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Ginger Bach presiding, is now in session. Please be seated.
Good morning, everybody, and welcome to the First District Court of Appeals. We have 3 cases set for argument today. When I call your case, if the person that is arguing the case could please stand up, state your name, and your readiness to proceed. The first case we have is Carter versus Dakota Trails. Thank you. Thank you. Okay, and next we have Wells Fargo versus Shear. Thank you. Okay, thank you. And then we have Edie versus Farmers Property and Casualty Company.
David Orlandini on behalf of the appellant and ready to proceed.
Thank you.
Gus Lazarus on behalf of the appellant.
Okay, thank you. We will be using the lights. When the yellow light comes on, you have around a minute left. When the red light goes on, that means that your time is up. If the parties for Carter versus Dakota Trails could please come up. And appellant's counsel, if you could tell me how much time you wish to reserve before you start, that would be great.
4 minutes, please, Your Honor.
Okay, thank you. Give me 1 second. Let me get my timer on. You said 4 minutes?
4 minutes, yes, Your Honor.
Okay. Okay, whenever you're ready.
Judge Bach, Your Honors, may it please the Court. Jeff Sindelar here on behalf of Tucker Ellis, LLP, arguing on behalf of defendants, appellants in this case. This appeal presents really a simple question of whether the plaintiffs are bound to an arbitration agreement, which there's no dispute Mr. Carter, in this case, signed multiple iterations of over the years. The plain language
How many are in the record? How many are in the record?
There are two copies in the record.
So those are the only 2 that we are to consider.
There are 2 copies in the record. They're identical, and plaintiffs agree and admitted that they signed another one in 2014. So by that admission, you have 3 separate agreements, 2 the language in the record, the third of which they've agreed that they've signed. So that's not in dispute in this case as well. And the plain language of these agreements and binding federal and Ohio case law make plain that these agreements have to be enforced here. The parties agreed to arbitrate the very types of claims presented in this case.
Counsel, how do we know that?
How do we know that the parties agreed to arbitrate these types of claims?
Yes.
So the arbitration agreements themselves contain broad language. They say that any claims between the parties they're agreeing to arbitrate. When a court is interpreting an arbitration agreement, the court first looks to determine whether it's a broad agreement or a narrow agreement. In this case, the language used clearly fits what is considered broad language by the courts. Then when you look at the Federal Arbitration Act and the Ohio instituting legislation for the Federal Arbitration Act, it's clear that there is a strong federal and state policy of enforcing arbitration agreements. So when you look at that broad language, plus the underlying substantive law, it's clear that this has to be interpreted as a broad form of language. In addition to that,
one of the issues being argued is the language, although it does say, any claim of any kind arising out of, but it says related to the nursing facility agreement. So what do we do with that language, related to the nursing facility agreement?
Yeah, so it says related to the nursing facility agreement. It's agreed by the parties that this relationship between the parties, Ms. Carter and Dakota Trails and the other defendants, is based on Ms. Carter's residency at Dakota Trails. So there's no dispute that there is a patient, resident, and facility agreement here, and there's no dispute that all of the claims here arise out of the nature of that agreement.
So that agreement that you just referred to, how is that presented in the record?
So that agreement is not in the record. The parties have been unable to locate it, Your Honor. However, under Ohio law, arbitration agreements may also be freestanding agreements beyond just a part of another contract. And here, the arbitration agreement itself is part of the record. There are 2 signed copies in record evidence. And the agreement itself specifically lists the types of claims that the parties are agreeing to arbitrate between them in cases such as
So it
this.
seems that your position is that the underlying agreement does not necessarily need to be part of the record.
That's correct, Your Honor. It does not need to be part of the record here. It's clear under revised code, I believe it's section 2711, that parties may separately enter an arbitration agreement that does not have to be part of another contract. And that makes complete sense here where the claims at issue are not breach of contract claims. So there's no need to look to the underlying admission agreement to determine whether there was a breach of that agreement. Rather, there are tort claims at issue here.
But it still says, and under both of the clauses, it still says arising out of or related to this agreement. Now, I understand that it also says these disputes include but are not limited to, and then it names a bunch of different types of claims. But it seems to me that that sentence is dependent on the first sentence.
Well, so it says that they have to be arising out of or related to the agreement. And if that was all that was here, we might have a much different scenario, Your Honor. But the fact is that the arbitration agreement itself, which can be a freestanding agreement under Ohio law, specifically dictates the types of claims.
But how can it be a freestanding agreement when it specifically refers to another contract?
That is because of Ohio law and federal law and policy on arbitration, which takes a broad view of arbitration agreements. You have cases out of the Ohio Supreme Court, and I'm thinking specifically, I believe it's the Ignacio case, out of the Ohio Supreme Court, Ignacio versus Clear Channel, that says that all doubts as to whether or not an agreement compels arbitration on a specific claim should be resolved in favor of arbitration. So because of this policy from the Federal Arbitration Act, which dates back to 1925, if there's any way that a court can interpret an agreement to find arbitration, compelling arbitration necessary in the claims, the court is compelled to compel arbitration. That's because there's a long-standing recognition of judicial hostility to arbitration agreements and a strong federal policy, which is also a state policy for the state of Ohio, to compel arbitration on claims when the parties have manifested an intent to proceed with arbitration. And an issue here is the way that plaintiffs would prefer this contract be interpreted in something they say explicitly in their briefing is that the arbitration agreement means nothing. That violates several canons of judicial construction. It renders an absurd result.
Well, counsel, I don't think that's what they're arguing. I think they're arguing that we have to look at the nursing facility agreement to construe what the arbitration agreement means. Let me give you some examples. What if Mr. Carter were to be visiting his daughter at the facility and he were to slip and fall in the parking lot? Does that claim fall within the arbitration agreement or not? And what if there were to be some car accident between Mr. Carter and a driver employed by the Dakota Trails facility off premises? I mean, we can imagine a whole bunch of claims between Dakota Trails and the Carter family. Which ones of them fall within this agreement and which ones don't, and how do we know?
Yeah, so you look back there to revised code 2711.01A, I believe is the statute, and it's the arbitration agreements under Ohio law. They can be either based on a contract or based on a relationship previously existing between the parties or that comes into existence at the time the arbitration agreement is made. And what you look at is, does the claim arise out of the resident facility relationship between Ms. Carter and Dakota Trails here. The arbitration agreement makes clear that the resident here was Ms. Carter, the facility was Dakota Trails, and if the claim arises out of that specific relationship, so if there's a slip and fall by Mr. Carter in the parking lot, that'd be a tough call whether that relates to the residency of Ms. Carter. If there was an accident, not on a work day where there's an employee of Dakota Trails and he just so happens to hit Mr. Carter with his car, that wouldn't be necessarily related to the residency and facility relationship.
What if they hit Miss Carter?
But if they hit Ms. Carter while it was as a part of her relationship with them as a resident, then that would fall under the agreement because it would be related to her residency at Dakota Trails. If after she left the care of the facility and there was an accident, that would no longer be related to her status as a resident because that residency relationship would have stopped at this point. But it's very clear that what plaintiffs are arguing is that the arbitration agreements cannot apply to any circumstance.
And so are you arguing that we should just strike out the language that says nursing facility agreement and replace that or construe that to mean relationship between these two parties?
I think to give effect to the parties' written agreement and their express agreement to arbitrate certain claims, including those explicitly called out for in the arbitration agreement, which mirror the claims brought in this case, you have to interpret the language about relating to the nursing facility admission agreement along with the specifically enumerated types of claims that should be arbitrated. And you have to see that when they're agreeing to arbitrate any claims related to or arising out of the nursing facility admission agreement, along with the types of claims that are expressly articulated, they are manifesting intent to arbitrate claims.
Well, what do we do with the fact that the arbitration agreement expressly excludes payment disputes? I mean, certainly the payment for this facility relationship would, we can impute, fall under the agreement that we're sort of imagining. We don't know what it says, but we can imagine that the exchange of payment for these services would fall within the agreement. And the arbitration agreement expressly excludes those. So what do we do with that?
Yeah, so in that circumstance, Your Honor, you go with a specific exclusion, the specific carve-out. Obviously, the parties did not intend for those types of claims to be included in the arbitration agreement. So you have a broad arbitration agreement with the backdrop of federal and state law saying that if there's a way to interpret the agreement that does compel arbitration, that's the path the court should take. But because you have a specific carve-out for payment or non-payment of fees between the parties, those types of claims would be excluded. Anything else involving the relationship between the parties does fall under the language of the arbitration agreement. So when you have a specific carve-out like that, that obviously would not fall under the arbitration agreement. All other claims related to the facility resident relationship would fall under the arbitration.
So if you're asking us to construe nursing facility agreement to apply here, under what rule of statutory of contract interpretation should we be using to do that?
So you use the rule of contract interpretation that the court's mission in interpreting a contract is to give effect to the party's manifest intent, looking at the express language of the contract. And
the express language says nursing facility agreement. So how would we part from that?
Well, it says nursing facility agreement, but you can also look at the language of the contract, which gives specific examples of the types of claims that are to be considered related to or arising out of the nursing facility agreement because they're expressly called out in the agreement.
Doesn't it bring us back to the beginning of that there's no agreement attached, no agreement that's part of the record that then by which the arbitration agreement is intended to apply towards?
Yeah, so there's no agreement in the record there's no copy of the agreement referenced in the arbitration agreement in the record in this case. However, because arbitration agreements can be freestanding agreements, and because this arbitration agreement explicitly lays out the categories of claims that are to be covered by the arbitration agreement, it's not necessary to look at the underlying agreement.
So aren't you in effect asking us to excise those words out of the contract?
No, not at all, Your Honor. You don't have to excise them from the language at all because the language of the contract provides you explicitly what types of claims should be considered as falling under the arbitration agreement. So you're not looking outside the language of the agreement and you're not excising anything from the agreement. To the extent that there's a consideration here, you could go one way or the other with the interpretation of the agreement. You fall back to the Ohio policy that you are supposed to try to interpret arbitration agreements.
Sure, arbitration agreements are favored. So I know you're out of time, but I still have a question, and I'm going to ask not to be taxed against you. So let's say we were to agree with you. There's also an issue with regard to the duration of the enforceability of the arbitration agreement. How would you handle that argument?
So in 2014, you have the first agreement here, and then you have two subsequent agreements. All of them would apply to any claims arising either prior to the entering of the first agreement and all subsequent claims. Again, because you have a broad arbitration agreement here, and there's case law in the briefs on this, when you interpret agreement with similar language to what we have here, where there's a broad arbitration agreement, you're supposed to try to construe all claims and ask, could they fall within the terms of the agreement? And looking again at revised code 2711.01a, you see that Ohio lets parties agree to arbitrate claims that are already in existence between parties with a relationship, which would be the case here, as well as all claims that may arise in the future. So given the broad language, the statutory language, and the strong federal and state policies at issue, all of the claims at issue in this case fall within the provisions of the arbitration.
So it seems as if your argument is premised on that this arbitration agreement was signed at the same time as some other agreement. Would you agree with that? Or am I misunderstanding that?
No, not necessarily, Your Honor. So there were multiple separate agreements, and each one of them independently compels the same result. And there's a case. So
is it your position that this agreement was signed in and of itself with nothing else signed that particular day? It was just signed?
So I'm not sure exactly when individual things were signed. These were signed by Mr. Carter at home and then mailed in. The practice was that he was sent a host of forms at any given time, and then he would sign and return the forms. And we know that there was at least one in 2014, as well as 2018, and in, I believe, February of 2021.
So that's what I understood from the record as well. So it brings me back to the duration question, because there is no duration in the arbitration agreement. I just don't know, I don't know where the duration comes from, and if it came from whatever agreement was signed coincidental to the signing of this agreement. So while there's arguments as to, well, it could just go on in perpetuity with this missing gap in the record, isn't it, it seems like it's an argument. I don't see anything to support that. And if you could give me authority, that would be very helpful.
Yeah. So there are other agreements that explicitly say they do last for 1 year, or they do have a 1 year duration, versus the arbitration agreement does not have such language. I would point the court to the Rock of Ages case we cite, which is 7th District Belmont at star page 3, which had a situation where certain agreements had a term and other agreements did not have a certain term in them, and the court said that, well, you're not going to import the language from the other agreements into this separate agreement. I would also
and that makes sense if all the agreements are before the court. The issue here is that we have whatever was coincidental, it doesn't seem to be part of the record.
And I would also look at the Nolde Brothers case from the U.S. Supreme Court and the ABC Home Care case, both of which explain that arbitration agreements naturally will extend beyond the length of underlying or related agreements, because if the parties agree to have a certain agreement enforced for 1 year, and 6 months after that agreement terminates, the parties bring suit. If there's an arbitration agreement, the arbitration agreement would still apply even though the underlying agreement had terminated.
Counsel, I have another follow-up question with apologies, and would also ask for the same consideration that it not be counted against your time. As to the time period question, if we don't have the underlying nursing facility agreement and the claims that have been agreed to be arbitrated, if we agree with you that they have, must arise from or be related to that agreement, how do we know the time period of the nursing facility agreement? And how do we know that the claims being raised in the complaint arise from or are related to that agreement if we don't know the time period in the underlying agreement? Do you understand the nature of my question?
Yeah, I understand the nature of your question there. And I think, again, what you would look to is the arbitration agreement itself explains the relationship between Ms. Carter as the resident and Dakota Trails as the facility. So using that Ohio backdrop of preferring or enforcing arbitration agreements, we would look for, as long as there was a resident facility relationship between Ms. Carter and the facility, you would hold that the arbitration agreement applies, because that's clearly what the arbitration agreement intends to manifest between the parties.
So we would just assume that so long as she's living there or residing there, being cared for there, that the nursing facility agreement is in place.
I think you would assume that the nursing facility agreement is in place, but beyond that, I think the arbitration agreement itself separately would compel that result, even in the absence of the nursing facility agreement, because you have to give some intent to and some effect to the arbitration agreement, rather than, as plaintiffs argue, the arbitration agreement should just be considered a legal nullity, which is exactly what they've argued below.
Thank you.
Thank you, Your Honors.
Thank you. Okay. Mr. Mooney, is that correct? You can come on up, and I'm going to give you extra time if you need it, just to make it fair. Whenever you're ready.
And I'm going to have you jump right into duration. The arbitration agreement clearly doesn't have a duration that's set in it. Why doesn't it go on in perpetuity?
I think we need to apply
Especially in a case like this where your client refused to sign any following arbitration agreements.
Certainly. And I think we need to look at the conduct of the parties in the signing of these agreements every year with a yearly packet of paperwork that was sent to Mr. Carter. When we look at the conduct of the parties signing an arbitration...
Is that clear in the record? Or is that, or are you asking us to kind of make a presumption?
Oh, I'm sorry. That is from the affidavit of Mr. Carter, which was in the record, which indicated that he signed agreements with a yearly packet of paperwork in 2014, 2015, 2016, 2017, 2018, rejecting not signing the agreement in 2019 or 2020, and then signing another agreement in February of 2021, but rejecting the agreement that was sent in October of 2021. If these agreements go on into perpetuity, as the appellants claim, there would be no need to send an agreement every year to Mr. Carter for his signature. And certainly there would be no need to send an agreement after he had, or I'm sorry, let me restate. I think the best evidence that these agreements do not go on into perpetuity is that the appellants sent, after the 2019 arbitration agreement was rejected by Mr. Carter, another agreement for him to sign. And if they believe that the 2018 agreement that he signed last went on indefinitely into perpetuity, covered all claims arising out of the relationship with Dakota Trails, there'd be no need to send him any other agreements.
If there were any terms, any changes in the arbitration agreement, wouldn't that then be a reason for sending a new arbitration agreement?
If there were changes in the terms, that would make sense. However, the arbitration agreements that were sent, Your Honor, were identical. There was no difference.
I don't know, because they're not part of the record.
What about this argument that we should just essentially strike out the term nursing facility agreement and replace it with some form of relationship?
I think that agreement, I think that argument would be an argument or an invitation to the court to ignore the plain language of these arbitration agreements. The arbitration agreements plainly state that they apply to claims arising out of or related to the nursing facility admission agreement. And the only way that they can apply to this relationship between Dakota Trails and Ms. Carter is if we completely ignore that language. That's the only way that this contract can be interpreted to apply to the claims that Ms. Carter's brought against the defendants, Dakota Trails.
Well, what about the argument that the all other disputes paragraph of the arbitration agreement lays out what types of disputes that it governs? That it's negligence, medical malpractice, tort, etc.
I think that Your Honor's touched on this in the questioning of the appellant's counsel. We have clear language that says that these torts are torts that are arising out of the nursing facility agreement. And there can be very different torts that can be committed by the appellants against the appellees, against Ms. Carter or her father, Gregory Carter, that would not constitute some tort arising out of a nursing facility agreement or the relationship between the parties to provide intermediate care facilities for Ms. Carter. This all other disputes paragraph still gives us that limiting language of claims arising out of or related to the nursing facility agreement, which is not evidence.
Isn't the key problem here that we don't know what the nursing facility agreement says? I mean, it could say a whole host of things. It could say that Dakota Trails is going to provide some specific form of medical care for Ms. Carter. Or it could say that it's going to provide a la carte services with some boxes that could be checked. Or it could be the most comprehensive agreement that's ever been written. I have no idea because I can't see it.
Precisely. And the appellants would want us to imagine that this agreement covers the relationship that they had with Ms. Carter, but it was their duty at the trial court level to produce that agreement and establish that they were entitled to binding arbitration here. That agreement's not in the record. It's not the place of the court to speculate in favor of the appellants what that agreement may or may not cover. It was their duty to completely clear up the court's concerns, thereby producing that agreement.
Are there any breach of contract claims?
There are not breach of contract claims. And specifically, I'd like to address the concept that an individual can have their throat slashed in the residential care facility, and the appellant's expectation that that is somehow a claim that arises from or relates to the relationship that they had with Ms. Carter to provide intermediate care facility services to her. There is no reasonable interpretation of these arbitration agreements that would stand for the proposition that an intentional battery against Ms. Carter, like slitting her throat, would be subjected to arbitration. There could be no meeting of the minds from Mr. Carter's perspective that that was what he was agreeing to do. It's also important to note that Mr. Carter did affirmatively reject the arbitration agreements that were put forth in front of him in 2019, 2020, and October of 2021. The claims that the appellees have raised in the trial court fall within these years when these arbitration agreements were rejected by Mr. Carter. Looking to the conduct of the parties again to define this term of when these arbitration agreements apply, because the arbitration agreements do not state the duration of their effect or whether they apply for a month, a day, a year. We have to look at the conduct of the parties to figure out what the term is here. The nursing facility admission agreement may provide us with some clarity as to the duration of which these arbitration agreements apply. That's not into evidence, and so we must look to the conduct of the parties. Looking to the conduct of the parties and signing an agreement every single year would indicate that the parties intended these agreements, if they intended them to apply to arbitrate the claims here at all, they would only apply to those claims that existed within the year between when those new agreements were signed.
Do we know anything about when the nursing facility agreement was in effect? Do we know that it covered the entire time period of these claims?
We don't know that. The only way we could know that is if it were in evidence, and it is not. There's no evidence in the record that indicates how long that nursing facility admission agreement applies. It could be yearly. It could be the entire duration of the stay. We just do not know, and it's not.
It could be until another one is signed.
Certainly. We don't have that information, and it was, again, the burden of the appellants in the trial court to provide us with that information by providing the nursing facility admission agreement.
Does it make a difference that some of the forms that Mr. Carter signed did have an end date, but the arbitration agreement did not?
I think that looking to the forms in their entirety, and again, the act of sending out the same forms every year for Mr. Carter's signature, we can infer that the intention is, even though the arbitration agreement is silent on duration, that much like these other forms, just like that entire packet of forms that's signed every year, the intent was for the duration to be 1 year's time. Even if we're to assume that the arbitration agreements are themselves valid, even if an arbitration agreement exists that covers the claims here, which it does not, we have to look to whether the arbitration agreements themselves are conscionable or unconscionable and voidable. In the arbitration agreements, it's very clear that the Carters are waiving all of the potential claims that they could bring against the appellants. And that's precisely what the appellants are arguing that they did, that they waived all potential tort claims that could be brought against them, including the claims identified in the complaint against them. However, the primary claims that a facility could bring against their own residents are exempted from the arbitration agreement, chiefly whether there's been payment on the services that they're providing. They still have the right to come into the court of law and seek a jury trial to resolve those questions. The contracts are very one-sided in that regard. Now, Mr. Carter is a layperson, In his affidavit, he was very clear that he doesn't have any education or training in...
What authority do you have that conscionability should be applied in this way?
I'm sorry, Your Honor.
And what authority do you have that conscionability should be applied in this manner?
I'm sorry, you're asking for the legal authority.
Mhm.
I'm sorry.
That this is the application of conscionability. There's a lot of contracts that are unfair,
Certainly.
but, you know, both parties enter into them, and
Certainly, and this contract goes beyond being unfair to the sense that it is unconscionable, not just because there's no mutuality of the commitment to bind the parties to arbitration. The primary claims that the defendant can bring against the Carters are exempted. The Carters' claims are not. It's plain to see from the reading of the arbitration agreements that there is not a mutual agreement here to bring all claims amongst the parties into arbitration, as the appellants have argued.
Isn't that typically the case with respect to arbitration agreements? I mean, they're typically used by a large corporation or something like that against a consumer or some person with less bargaining power.
That's correct, and it's not just the question of the bargaining power of the parties. That is one of the factors to take into account.
And yet, we're still instructed under the law and statutes to favor these agreements.
Certainly, but the agreements are not to be favored without any consideration for whether there is a mutual agreement to arbitrate all claims or the fairness of the agreements. The courts are still permitted to look to the conscionability of the agreement and find the agreement voidable, where it strays into the territory of an unconscionable agreement that is unfair to the layperson party, that arises to a level of unconscionability. The demand for the services that the appellant is offering as an intermediate care facility is very high. The supply is quite low. The care that Ms. Carter needs is not just the sort of care that can be provided at home, or else Mr. Carter would be providing it. The fact that this care is of such a level that it may even affect her well-being or safety to not receive it places Mr. Carter in a particularly vulnerable state. The sending out of these arbitration agreements without any kind of meeting of the minds, a sitting down between Mr. Carter and the folks at Dakota Trail to go over the contents of the agreements, also points to procedural unconscionability here.
Is that a requirement, though? I mean, do you have any authority saying that that is a requirement?
No, that's not to say that it is a requirement, but it does point to an indication that there was not a meeting of the minds here between Mr. Carter and Dakota Trails that would have allowed him to negotiate in equal standing with Dakota Trails.
Okay. Didn't the arbitration agreement make clear that his signing it did not affect whether Dakota Trails would take her as a resident?
It did say that. Yes.
Okay. And that's first. And then second, the fact that he signed it some years and not other years, doesn't that cut against your argument?
I think the signing of the agreement in certain years would indicate that Mr. Carter perhaps did not understand whether there was an ability to reject this agreement. And once he came to the conclusion that he could, that is exactly what he did. Now, the agreements are, I think, very plainly rejected by Mr. Carter in those years. The act of sending 14 out of 15 documents that he was provided to sign back to the facility, signed with his name, exempting that agreement is a pretty clear rejection of the terms of that agreement. And he rejected that agreement in both 2019, 2020, and then again on October 20th of 2021. And that act of rejection, it can only be interpreted as his refusal to agree to arbitrate the claims that are at issue here. For the reasons that I've stated, Your Honors, I'm concluding here by stating that the court should affirm the holding of the trial court that the plain language of these arbitration agreements requiring that the claims submitted to arbitration arise out of or related to a nursing facility admission agreement is limiting language. And without that agreement in the record, the appellants have not met their burden to show that they are entitled to arbitration here. Even if the agreements are themselves valid and interpreted to extend to the relationship between Lauren Carter and Dakota Trails, Mr. Carter rejected these arbitration agreements in the years that would apply to the claims that have been brought in the complaint against the appellants, and therefore those arbitration agreements would not apply to the claims that Lauren Carter has brought against the appellants. And finally, the agreements are procedurally and substantively unconscionable and should be voided on those terms if they are not interpreted to be not in effect during the years that are at issue. Thank you.
Thank you. Mr. Sindler, you have 4 minutes.
Thank you, Your Honors. Just to address some of the points raised in order. First, as to plaintiff's desire that we look to the conduct of the parties, there is a very clear rule that the court should interpret agreements looking at the language that the parties used when they made an agreement, not based on after the fact, ad hoc, self-serving affidavit testimony. There's a reason for that. Obviously, after a dispute arises, parties can come up with all sorts of justifications and explanations for how they want the contract to have read. But we look to the contract that was written and signed by the parties prior to the dispute arising, and that is what I'm asking the court to do here.
Counsel, is there any evidence at all that a nursing facility agreement was actually signed?
I'm not aware of that one way or the other, Your Honor. We don't have that in the evidence. We don't have that in the records. What we do know is that there were multiple arbitration agreements that were clearly signed, and that the court's instruction from the case law and the canons of construction are to try to give effect to those agreements, which the parties absolutely did sign, that plaintiffs admit that the parties absolutely did sign.
And we have other documents from the packet that was sent out, right? We know
Yes.
that there were other documents back and forth between the parties, right?
Yes, we know that.
But we don't have a nursing facility agreement in that packet.
We don't have a nursing facility agreement. We don't know if one was included in that packet. I believe Ms. Carter was a resident from 2002 up until very recently, so it's possibly the case that we just don't have that because the original agreement was over 20 years old, and the earliest example of an arbitration agreement we have is for 2014. So it might be the case that an arbitration agreement was not entered in 2002 or whenever the first agreement was signed, and that the parties subsequently agreed to arbitrate.
What about this claim? I mean, one of the allegations in the complaint is that Ms. Carter's throat was slit and an intentional tort is being alleged as a result. What about this idea that Mr. Carter would not have contracted with Dakota Trails for that particular action? Well,
again, you have to look at what Mr. Carter actually did agree to and what he actually did sign, and that was an agreement where he did agree to arbitrate claims sounding in tort, violation of residents' rights, medical malpractice, things of that nature. So the agreement that he did sign did cover such agreements, and there is both Ohio Supreme Court and U.S. Supreme Court and Ohio Supreme Court precedent that nursing facilities may have binding arbitration with their residents, and there are broader public policy reasons for that. There's concern about reducing the costs to entities that provide nursing and intermediate term care, and one of the ways that you reduce costs is by having binding arbitration of the parties, and that's a larger public policy consideration. After the fact, there may be a desire to show sympathy for someone who appears sympathetic when there are allegations of harm caused to them. But to enforce the rule of law and the broader policies we have, including the policies of enforcing arbitration agreements, we have to look at what the parties actually did agree to. And I'd reiterate here, Ms. Carter and Mr. Carter are not waiving any claims by no means. They're agreeing to binding arbitration, which the United States and the state of Ohio both recognize as equally valid to bringing a claim in a court of law. That's why for nearly 100 years now, we've had the Federal Arbitration Act, and states have followed the Federal Arbitration Act and enforced arbitration agreements such as the ones at issue here. I'd like to look at the idea that
You have about 20 seconds.
Mr. Carter did not reject any of the subsequent agreements. He didn't sign them. That was not a way to revoke agreements. The last agreement he signed was in February of 2021. So if that one only lasted 1 year, as plaintiffs are arguing, that would have extended until February of 2022. I believe my time is up. Thank you very much, Your Honors. I appreciate your time today.
Thank you. Your case has been submitted, and we will issue a timely decision. Okay, and if I could have the parties for Wells Fargo Bank versus Shear come up, please. Okay, Mr. Shear, you will have 15 minutes. Would you like to reserve any time? 5 minutes? You got it. Okay, whenever you're ready, you can get started. And again, when the yellow light goes off, that means you have about a minute.
Okay. This is a case where there's no contract that holds us to where for foreclosure. Let's see, I'm sorry.
Before you get started, I just there was a supplemental authority that was filed. It was served to you via email. Are you aware of that?
No. I have no idea what that even is. All I know is Wells Fargo and I do not have a contract. I go all the way back to Washington Mutual. Washington Mutual and my wife and I, we signed a note and mortgage with Washington Mutual. And we have a complete line of ownership from my original sign with Washington Mutual all the way through to Chase Bank. Chase Bank has the original note and mortgage with Washington Mutual. Now, my question to you, and actually this case has been dismissed twice for just lack of evidence, and I'm trying to figure out what Magistrate Bachman saw, because Bachman dismissed it twice, and he said there's just no evidence. So what you just went through with contract, I kept hearing contract. What's with the contract? I do not have a contract with Wells Fargo Bank. It says here, Chase Bank got an assignment from the FDIC. And when the FDIC, when I put you through with Wells Fargo or Washington Mutual, all the way through when Washington Mutual went out, the FDIC took over. We have paperwork from the FDIC where it went over to Chase Bank. And I know you said I couldn't use this, but there's a lot of information on here. This is the oral argument that I was going to submit. If you look through here, there's all of the documentation of what Chase Bank said that they did. They, in quotes, in an affidavit, stated that they got this note and more. Well, no, they didn't say a note. They actually said they only got a mortgage through the FDIC. The mortgage through FDIC is a completely different number from what my wife and I signed. We had signed no paperwork with that particular number on it.
When you say completely number, is there, I think there's an additional character, is that, am I?
Well, not only that, I mean, if you were to put that into a computer, and I'm completely illiterate when it comes to computers. So I told you in my thing, I didn't even have a calculator when I went to college. I mean, if you didn't do it in your head, you didn't do it. Okay. But here, I have no contract with Wells Fargo. None. And, a foreclosure case is based upon did you breach your contract? Well, I have a contract with Chase Bank, but not with Wells Fargo. Chase Bank never sued me. And, you know, really Wells Fargo, when I've called Wells Fargo, even today, if I were to actually take my cell phone out, call Wells Fargo, I've called them. I gave them my account number that you have there, that 10, and that they have no record of it. They said, okay, Mr. Scheer, what's your social security number? I give them my social security number. They have no record of it. You have a check that's listed in here, okay? I sent them a check. They sent that check back to me. Mr. Scheer, would you please put your proper name on there, put your account number, and please put your address on there, a proper address. Well, Wells Fargo didn't even know that they had a mortgage on me. I told them that they had a mortgage on me. So this is how crazy this thing is. And I have everything in this here, this oral argument, is everything I have submitted to the judge in the trial court. I mean, he had all of this information. And then if you really look at the way the affidavit is written, I had talked to the FDIC. I checked with the Consumer Financial Protection Bureau, and I've gotten different responses back. The response from the Consumer Financial Protection Bureau is that Wells Fargo contacted them, and they said that they're not the company. Here's the status. Company responded. Complaint does not belong to them. That's Wells Fargo. They also put in a letter to the Consumer Financial Protection Bureau. Wells Fargo is not the investor or owner of the loan in question. This statement was, to the Consumer Financial Protection Bureau. The Consumer Financial Protection Bureau has actually sued. Well, no, they don't sue them. They just fined them $3.7 billion for corruption. Now, I can't say that Wells Fargo was corrupt in my case because they had no idea I even existed, which is kind of I know all three of you look at me and like, well, how can you have a foreclosure judgment against you when Wells Fargo doesn't know you even exist? And that's my question.
What's the current status of the house?
The house? We're living in here. And I've contested it. And as far as the house goes, it went over to Irene Sandra Schubert, who is, that's under the legal name given to her by the court. And that was actually signed over prior to the sheriff's sale. So anything prior to a sheriff's sale, what should have happened, and the attorneys didn't do that, they should have examined the title, because the title was in Irene Sanders' name, and they should have at that time, if they felt that they needed to go ahead and file a suit against Irene Sanders Schubert, they needed to go ahead and cancel that sheriff's sale and then go ahead and amend the lawsuit, put her name on there, and have her as another defendant, which they did not do. So at this point in time, Irene Sanders Schubert is really the owner of the house. And let's see, the other thing that came up is actually on when you talk about mortgages. Okay, if I were to say, Ms. Brock, you're the recorder's office, and You, Your Honor, are the Chase Bank, and you're Wells Fargo, okay? Now, what happened was Chase Bank went ahead and wrote a mortgage, sent it over to the recorder's office. The recorder sent it back to Chase Bank. Chase Bank said Wells Fargo and gave the address of Chase Bank. Again, that's in this oral statement. You can actually read how they wrote it up. The other thing is that you cannot, under federal guidelines, you cannot pass an assignment through a company that does not exist. That's definitely a shell company. People do that in order to protect and hide money. This is where laundering takes effect, and that's why the Federal Reserve Bank said, nope, you can't do that. So this mortgage that supposedly went over to Wells Fargo Bank is really not a valid mortgage. It can't be.
Mr. Scheer, if you'd like to reserve 5 minutes, your time's up.
Yes.
And I have one question before. Mr. Scheer, what's your current email address?
The Property Exchange Group @gmail.com.
All right, thank you.
Thank you, and you'll have 5 minutes when you come back up.
Okay, thank you.
Ms. Safira, am I pronouncing that correctly?
That's correct. Good
All
morning.
right.
I'm here on behalf of Wells Fargo, and wanted to start by saying that the action here before the court, this is the third appeal, just give a very brief history. There was an affidavit.
You're fine. You're
Okay,
fine.
and a motion for
Can
summary
you
judgment. Yes.
please share the current status of the property?
It is my understanding that there has been a sale.
I shouldn't have said you're fine, perhaps.
You don't want a history, you don't, is my understanding, is that
Yeah.
We're
correct?
familiar with the
Okay.
case.
Yeah.
So my understanding is that there was a sale of the property, that the property was sold to the lender, and that there was a confirmation of sale entered, I believe, on November 22nd, and then on November 27th, that was mailed out to the parties. At least that's the journal entry in the record.
And you filed, I think it was Friday,
That's correct.
notice of supplemental authority.
That is correct.
Okay. And so I asked Mr. Scheer about it, and he said he's not aware of it as of yet.
It
the email
was served on
address.
him via email, Your Honor.
Right, no, I noticed that, and I noticed that the email address that he shared with us this morning was within a filing that he had done, where he had put the email address. Obviously, Mr. Scheer hasn't had an opportunity to respond to the supplemental authority.
Yes, and it's my understanding under the local rule that we could have filed that even after the oral argument. We thought it would be best to file it before the oral argument, just to raise yet another reason why this court should dismiss this action.
Okay, I appreciate that.
I'm here to answer any questions that you have. It sounds
Yeah.
like you might not be interested. I think the only other thing I want to...
I do have a question.
Okay.
So Mr. Scheer, in his arguments today, talked about the titling of the property. And forgive me, Mr. Scheer, I can't remember the name that you discussed. It was a female name with regard to the titling of the company, of the property, that he says is part of, as I understood, it was part of the title.
Irene Sandra Schubert.
Yes.
Okay, thank you. Was that argument raised previously?
Yes, Your Honor, that was raised here before this court, and we did file a response to that to say that there is a lis pendens doctrine that would apply, and so that even if there was a person who had an interest in the property who was not properly named, that that person would take subject to all of the liens and actions that were against the property. I do not recall, as I stand here, whether there was any ruling in that regard, but that was addressed by this court.
Okay, so that was raised and was fully argued previously?
I don't believe it was argued in the trial court.
Okay.
So that's why I know that I addressed it with this court. We probably indicated that it was improper to have been raised without having been raised in the trial court, but we did respond to this court. And that the woman who he's referring to is, I think you all know, his wife. and that her name apparently was wrong for 40 years in the record, and then it was, discovered that she really had a different name, something to that effect.
Thank you.
So, Your Honors, there are multiple reasons why this appeal should be dismissed, primarily because the issues that are raised were already decided by the trial court. They were then affirmed by this court in a different appeal. Some of those issues were then appealed to the Ohio Supreme Court, and the Ohio Supreme Court declined jurisdiction. And then when the matter went back, there were 22 motions that were denied in January of 2022, I believe, and there was no appeal of that decision until March. That was the second appeal to this court, and this court decided at that time that it did not have jurisdiction. The case went back down. These issues have all been either resolved by the trial court, appealed and affirmed, or never appropriately appealed. And therefore, there is just no recourse that can be given by this court at this time based on this appeal. And all of the information, I know this court did strike the most recent filing by Mr. Scheer, but all of the information that's attached therein never was properly submitted to the court. It was never authenticated. There was no affidavit that accompanied it. Much of it is dated, if you look closely, after the decision in this court on the motion for summary judgment. And for that reason, there's no evidence at all disputing what was established in the motion for summary judgment filed in 2019, and that is the chain of assignments for the mortgage and the note.
Counsel, you
yes.
could perhaps help us clarify exactly what it is that is on appeal before this court. You mentioned the 22 motions. It looks like the order that's actually being appealed here relates to really only two findings: that the bank, Wells Fargo, is the real party in interest, and that there was a Rule 11 sanction imposed on Mr. Scheer, and that's it?
Yes, so the initial one that you mentioned, that real party in interest standing, that has been resolved. I mean, that's the issue that was the motion for summary judgment for which the bank was entitled to foreclosure. And then that foreclosure went up on appeal. On appeal, it was affirmed. It went to the Ohio Supreme Court. It was declined.
So your position is res judicata as to that issue? As to that,
absolutely. So there were two things that the trial court did in October of 2022, which are the appeal before the court right now. And that is it denied a motion to dismiss that was filed by Mr. Scheer, and that could be considered maybe a motion to vacate the judgment, but it was captioned as a motion to dismiss, and it ordered sanctions, to your point. I'm not certain that it specifically referenced Rule 11, but it did order sanctions. The sanction against the Scheers was that they could not file anything else having to do with 4 or 5 different subjects without getting prior leave of court. So that was a sanction that was issued against them. That was appealed, but there was no argument raised by the Scheers in the Court of Appeals on either of those grounds. They really just brought up things that have already been resolved by the courts unrelated to those two issues.
All right, and so just to clarify your position as to the motion to dismiss and the sanctions, you believe those are res judicata as well?
I believe that they have not been appealed here, so yes, I mean, they've been appealed, but they've not been argued. So on that ground, the trial court's decision should be affirmed, correct?
Thank you.
I think, does that answer your question?
Yes.
So for all the reasons stated herein and in our briefs, we believe the trial court's decision should be affirmed. Thank you.
Thank you. Mr. Scheer, you can come on up and you have 5 minutes.
Mr. Scheer, I used a legal term with Wells Fargo's counsel, and I just want to make sure you understand it. I used the term res judicata, and that means that an issue has been decided before. So I just wanted to clarify that for you.
Okay, you decided an issue based upon the double dismissal rule. And to be straight with you, the Ohio Supreme Court split. Yes, I lost. But my argument that I brought up, some of the judges considered it and found it a valid argument. So I just wanted to kind of clear that one up. And then the second one, I'm going under Rule 60B5, where if you find additional information, I can bring it up and present it to the court, which I did with Judge Nestor. And
is that what you're appealing to us?
yes, but this whole thing, when I really got into it and different authorities that I had talked to looked at it and said, Mr. Scheer, Wells Fargo doesn't have a note on it. See, Chase Bank never assigned the note over to Wells Fargo Bank. That's number one. Number two is I brought up the fact federal laws prohibit an assignment of mortgage to go through a shell company, but Washington Mutual did not exist in 2014. Washington Mutual actually went out October the 15th, 2011, and they closed their last office in Charlotte, North Carolina, and that's when they closed it. So there was an illegal transfer of mortgage from Chase Bank over to Wells Fargo. So Wells Fargo really does not have a valid mortgage.
Mr. Scheer, was there anything new that you presented in your motion with the 6dB5 that you're talking about? Or was this information that the trial court had already looked at?
No, this is all new. This
Okay.
is all new. I presented this to Judge Nestor, and also I found out from, I filed with the Consumer Financial Protection Bureau. I went with the various, I forget all the different things I went through, but the Office of the Comptroller, and I filed with them. Everything came back, said, Mr. Scheer, file a motion and file a grievance with the Consumer Financial Protection Bureau. That's when Wells Fargo came back and said, look, and I read it to you that, we're not the party to be asking these questions to, and not only that, we are not your investor, and we have no money in the house.
Mr. Scheer, your opponent has told us that the house was sold to the lender on around November 22nd of
Okay,
last
now
year.
see, I question lender. When you say lender, that was sold to Wells Fargo.
Okay.
And see here.
Well, let me just stop you there because I want to make sure that I understand what's happened.
Mhm.
So, do you dispute that the house was sold to
Definitely.
Wells Fargo?
Wells Fargo is not our creditor.
Well,
Period.
let me separate out the legal terminology.
Okay, right. Okay, gotcha.
Just as a factual issue.
Okay.
I'm not going to hold
No,
it
no,
against
I
you.
understand.
Yeah, I just want to understand what's happened.
Mm-hmm.
Around November 22nd of last year, was the house sold to Wells Fargo?
September the 27th.
Okay.
And prior to that, Irene Sandra actually took title to the house.
Okay.
Okay, so when the house is actually sold, Wells Fargo did not buy the buy the house as such because it wasn't under my name. The order that was signed is Patrick C. and Sandra A. Scheer, and those are the two. When you go to a sheriff and look on the sheriff's deed, the sheriff's deed just names those two people. Irene Sandra is not included. Okay, so she had nothing to do with it, and the house, is in her name. And this is all of the liens that were released were in Patrick C. and Sandra A. And here again, I go back to Washington Mutual.
Mr. Scheer, your time is up. If you'd like to take about 15 seconds to wrap up, you may do that.
All right. Thank you. I got the hook. Okay.
Everybody gets the hook. It's an equal opportunity hook.
Just putting this whole thing up. Wells Fargo is not our creditor, period. They admitted themselves. Again, I go back to the fact that they admitted that we are not your investor, and we are not, we have no money invested in your house, and if you actually, I know that you rejected my oral argument, but if you would go through and read the documents, read the documents in here, you'll understand exactly what I'm telling you.
Okay, Mr. Chair, your time is up. Thank you very much for your arguments. Your case has been submitted, and we will issue a timely decision. We are going to take a very brief recess before the next case.
All rise. The Court of Appeals, First Appellate District of Ohio is now in recess. First Appellate District of Ohio is now back in session. Please proceed.
Okay, our last case to be argued today is Edie versus Farmers Property and Casualty Insurance Company. Mr. Orlandini, am I pronouncing that correctly?
Yes, Your Honor.
Okay. How much time would you like to reserve?
5 minutes, please.
Okay. All right, you can come on up, and whenever you are ready, you may get started.
Thank you. Good morning, Your Honors. Again, my name is David Orlandini, and I'm here on behalf of Appellant Farmers Property and Casualty Insurance Company. And I am here to ask this court to correct the error made by the trial court in allowing appellee to receive discovery of attorney-client and work product documents created during active litigation between the parties when establishing a rule of allowing discovery, even in bad faith cases, to privileged documents such as attorney-client and work product documents.
Counsel, what exactly are those documents? Was there any kind of privilege log produced in this case?
There was, Your Honor. There was a privilege log provided to the trial court. The documents consist of a variety of items, including claim logs. And if you're not familiar with a claim log from an insurance company, I can explain that. But
where would we find that in the record?
The privilege log?
Mm-hmm.
I'm not entirely sure, Your Honor. It was provided to the court as part of discovery, and if it was not included with the record, I'm not sure I can answer that. I'm not sure how to answer that one at this point, Your Honor, but a privilege log was provided to the court and the counsel.
So you're not asserting that the entire claims file after the magic date, and I do not have it memorized, no, it's in 2022 sometime. You're not asserting that that magic date acts as a complete bar to the claims file. There are specific documents that you've identified in the record that you want to identify as privileged?
So to answer your question, Your Honor, no, I do say that once the lawsuit is filed, that underlying underinsured motorist lawsuit is filed on August 27th of 2021. Anything after that is not discoverable. It is anything, correct, Your Honor. That is our position.
Well, let me ask you about that, because I can make an assumption that, for example, Dr. Paley's report would be in the claims file. Why would Dr. Paley's report be subject to either work product privilege or attorney-client privilege?
Fair, Your Honor. I guess that is a good point in a sense that third-party documents that might be contained within that claim file that have no associated privilege with them might be discoverable. And I apologize if I did not think that that was where your question was going.
So it's not really anything in the claims file. It's not the whole claims file.
In this particular case, Your Honor, I guess the question is how the court looks at some of the information that was contained, if I may. We have correspondence from counsel, hired counsel representing farmers, that forwarded along discovery responses, the medical report, things of that information, with their opinions, their letter explaining that. This is a type of information that we have said is privileged and should not be subject to discovery. The actual medical records, the Dr. Paley report, and the
Was that
exhibits
turned over? Was Dr. Paley's report turned over?
to my client in discovery.
Was it turned over to the plaintiff in discovery?
Dr. Paley's report was the plaintiff's report. That was their doctor's report.
But they asked you for your claims file, and that would have been in there, I think. Did you turn it back over?
That particular medical report, we did not turn that back over. They had already had it, meaning they provided it to us. That's their expert. And so, no, that was something that was not necessarily produced. But to I think, piggyback a bit on what you're asking me, Your Honor, what we have said is that once the lawsuit was filed, any communications and anything in the claim file after that date that would be attorney-client or work product documents, that's not subject to discovery. We're in active litigation. And if you look at Boone, the Boone versus Van Liner decision, we believe that that decision clearly supports our argument. The Boone says that only documents that would have been created before the anticipation of litigation could be subject to discovery because they're unworthy of protection.
Was that a case of where the claim was denied?
The Boone does have a denial claim in it, yes, Your Honor.
So how would that apply in this case? Because this is not a denial claim.
That's correct, Your Honor. And so what has happened is courts, both applying Ohio law, both within state court and within federal courts, have said you have to come up with a constructive denial date. And a constructive denial date, as been determined by other courts, has been either the date litigation is filed, or there are some courts that have said the date that the answer is filed by the insurance company in the underlying litigation. I understand there's the Uncles Bay decision that appellees rely upon that talk about in a foot-dragging case going to the date that payment is made. We believe that, Your Honor, the appropriate position in the law of Ohio is that a constructive denial date, when examining Boone and its progeny and its exception to what is privileged, you do have to look at what the purpose of Boone creating that date of the denial. That is, anything before that is created not in anticipation of litigation. Thus, anything after the denial would be in anticipation of litigation and then protected.
But isn't that, I mean, in the Unclesby case, similar to this case, the underlying litigation was over.
Well, they were filed at the same time, but then they settled the UM claim before settling the bad faith claim, and the bad faith claim proceeded forward separately.
Correct.
Yeah.
So my point here is, it's unlike the Boone case where it was ongoing at the same time. In Uncles Bay and in this case, the underlying UIM case had been settled, was over, was done when the litigation and the request for the claims file happened.
I would agree that they're similar, Your Honor, but I also think that a closer look at the Uncles Bay decision does still provide guidance to this court to the effect you find that case influential on your decision. In the Uncles Bay court, the trial court did conduct an in-camera review, something the trial court did not do here. And they were looking to make sure that the only documents that would be discoverable would be documents that, if in fact they were privileged, that went toward the theory of the bad faith. Whatever that particular theory was. And in the Uncles Bay case, similar to here, it's a foot-dragging theory of bad faith. We didn't have that here in this case. And that is part of the problem. That's part of the reason we are here. What the Uncles Bay court did do is it did define a different date of constructive denial, one that we do not want this court to adopt.
What is the in-camera inspection for? Is it to identify privileged documents in the first instance, to assess whether privilege is overcome by the bad faith claim, or something else?
Sure, Your Honor, I would imagine the in-camera and then the statute that I cite into the brief, you have an initial assessment by counsel saying, hey, these documents are privileged. And then the court and the in-camera can then review. Yes, I agree, they're privileged. Or no, I don't think these are privileged, so they're not subject to protection initially. But secondarily to that, if the court is going to say that in a foot dragging case, the date of payment is the constructive denial date as defined by Boone, when the in-camera review takes place under those circumstances, we are submitting to this court that the process that the trial court must then do is to only allow discovery of otherwise privileged documents that shed light as to the theory of bad faith that is being alleged in the case. Doesn't mean that they're carte blanche entitled to everything, like the trial court ordered.
Would you say that the privilege log would give some direction as to what would happen in that in-camera and what would be reviewed?
I believe so. For the trial court, Your Honor, yes.
Okay.
That was part of my understanding. This is me speaking just myself as to why partly that privilege log was specifically requested by the court in at least some of the hearings that we had. And then when there was no in-camera inspection, I was a little surprised personally, just myself. And I think that that's part of what we're here to correct. We have, looking at the history of the case, we have a lawsuit that's filed, underlying case. Counsel is hired by the defendant, Farmers in this case. And I say Farmers, it actually was a metropolitan policy, but Farmers purchased them, so I just refer to the defendant as Farmers. They had counsel. That counsel was advising them through the process, giving them information, providing communications and advice. All of that was made available for discovery without a review by the court and without making any sort of determination as to whether any of that had any bearing on the claim of bad faith that is before the trial court.
The information provided in your briefing is that Farmers was given an initial packet that had, from your perspective, some very brief medical information. And that I'm just repeating back to you what I read in your briefing. And that later on in the process, after being sued, you received Dr. Paley's report that was much more extensive and identified, I'm not a medical expert, I'll butcher the terminology, but received much more detailed information about Ms. Eddy's injuries and ongoing medical care that she was going to need. And that's what caused the abrupt change from $38,000 to $150,000. If that's the case, and Farmers was acting in good faith all along, and it was Dr. Paley's report that caused the change, why not disclose the information? What would be subject to attorney-client privilege and work product privilege if what you're telling this court is true?
Well, Your Honor, if I left you with the impression that the initial demand was somehow another sparser light, I apologize for that. They did provide most all the medical records that were available at that point in time. So if I gave the court that impression, I apologize for that, and I apologize to plaintiff's counsel if that's the situation as well. They did, in looking at that, there were not all of the records that would have been wanted and that were asked for by claims at that moment in time, and we're talking about, and I know I'm out of time, and so forgive me, Your Honor. And it was pre-UM lawsuit time here, so we're talking before the underlying lawsuit was filed. And so there was still a need to gather some more information at that point, but they did provide a large number of records. It did include somewhat of a report from a treating physician. Dr. Paley, though, provided a very different report, and that's what I was attempting to highlight in my briefing.
Thank you.
And I just have one super quick question. I think it's a super quick. With regard to RSC 2317.02, what is your position, whether it applies in this case or not?
I do believe it applies in this case, Your Honor, and I do believe it compels at least a prima facie showing of a bad faith so the trial court knows what the issue or theory of bad faith is that's being alleged. So your position is, despite the language in the statute, that it applies to written material? I believe it should apply to written material, yes, Your Honor. Okay, that's my position.
I'll see if they want to address that. All right, thank you.
Thank you very much.
Thank you.
Thank you.
Mr. Lazarus? Whenever you're ready.
Thank you.
Counsel, was there a privilege log in this case?
Your Honor, there was after some discussion, there was a privilege log as I recall it, everything up to the date of the information that was provided. I don't believe, as the court identified with my friend on the other side, there was a privilege log that we received, and certainly not one in the record, for the area of the time of the claim file that we're disputing, which is from the date that the UIM litigation was filed until the date of the benefit payment date, as we call it. So I don't believe it's in the record. I don't recall ever seeing it as I sit here right now and as you asked the question. There was one, and we did discuss it for that prior date, where they have provided a redacted version of the claim file.
And I recall seeing information in the record and perhaps discussion at the hearing of information you were trying to get from I think it's April 2021, before that, where there was some debate and discussion of redaction in the documents that had been turned over to you, and a privilege log as to that information, or redacted information, but nothing as to the disputed window from April 2021 to May 2022, or whatever those magic dates are.
That's correct, Judge. And I don't know if one was provided to the trial court and not to us, as I think there were some perhaps requests by the judge for things to be sent just to her. I don't entirely recall, and it's not in the record clearly, so I don't want to make a definitive statement on that. But if counsel's saying that may indeed be true. The trial court has more information than we ultimately.
Is that a document that you should have received?
Absolutely. We would say that the Ohio Rules of Civil Procedure and case law supporting it says that when there's a privilege dispute, it's the party asserting the privilege that has the burden to show the privilege. And the first step of that is to show a privilege log, which should shed some light on getting to that burden, and I think more importantly, allows the challenging party to be able to challenge with some specificity exactly what it is why what they're saying is privileged is or is not privileged.
And did farmers ever turn over anything from that magic time period, the 2021 to 2022 time period that's in dispute? Did they ever turn over anything from the claims file?
Nothing from when the UIM litigation was filed until the benefit payment date. That's correct, Judge. Nothing was turned over from those dates. Thank you.
And what would you say is the legal effect of the lapse of the privilege log?
We would say that when you don't provide a privilege log or when you don't meet your burden generally as the party asserting privilege of work product, you cannot succeed because you carry the burden. You're the party that asserts the privilege. You have to show that there is a privilege. There's been no showing. A privilege log is the preliminary step in that process. So the party asserting the privilege fails for that very reason would be the legal effect. And
there seemed to be a discussion this morning from opposing counsel about how he was awaiting a notification for the in-camera, didn't receive it. If he was waiting to bring forward a privilege log, if he was intending to bring one forward with that, after that, how would you respond to that then? In other words, I'm getting to the argument of no in-camera review is what I'm getting to.
Understood. So, and to get kind of the specific question, I understand your question to be, Judge, if the trial court had said, we're going to do an in-camera review on this date, and then if counsel had provided a privilege log after that time?
It seems as if, I think the direction counsel was going is he was waiting for an in-camera review, didn't get one, and I think that perhaps the intent was to do the privilege log thereafter. Now he's arguing that it was error not holding the in-camera review.
Right. So in terms of the timing of providing the privilege log, had one been provided on that, I think the relevance of that particular component is simply that we would need it with enough time to be able to brief the issue. So from plaintiff's perspective, that's the practical application. In terms of the need for an in-camera review generally, the statute 23-1702, this court held in grace, applies to testimony, not documents. So I think that's a settled issue as it relates to this court. In terms of outside of testimonial information, so documentary information, I think what you find in the case law that's been cited by both sides is that when the in-camera review is often used or useful is particularly in the combined UIM or DEC action bad faith cases when they moved on the same track for some period of time, perhaps before they were stayed and severed. And in that case, you have this idea of, okay, you have documents from litigation, the underinsured motorist claim, and the bad faith claim perhaps mixed together, and they're still both active. And then the in-camera review, you can see where it would be useful for the judge to separate out one for the other. This case is unique in a way that's helpful to the Eddies
because the underinsured motorist case was completely resolved before the bad faith case was ever filed or alleged. So there's no danger of prejudice to anybody, to the insurer in this case, because that they had their defense strategies, all that were irrelevant at that point because they were concluded. There was no prejudice that we were going to have a window into their strategy at the trial of the bad faith case. So this case is uniquely, in affirming the trial court's order, this court's ruling would necessarily be narrow and would go less far than case law currently on the books, because our case was not a combined case, because it was subsequent, UIM, then bad faith. That makes it a cleaner and much less prejudicial case to the insurance company. And so that's important. I hope that answered a long way of answering your question. So outside of testimonial, in-camera can or cannot be used. This is the exact case when it would not need to be used. The National Insurance Fire Union case from the 10th District that we cited in our brief, the same thing. They said the entire claims file should be provided. No in-camera review is necessary because there's nothing to separate out, essentially, and that's the case here. And broadly speaking, this case is about whether an insurance company can unreasonably delay in paying the claim of its insured and then hide its real reason for doing so. It's about the transparency of whether the average premium paying customer gets the information necessary to challenge the decision of a large, often corporate insurer. And as it's generally understood, we know insurance, they're investing the proceeds of our premiums and paying out the claims as they need to, but they're investing it while it's not being paid. And we trace the history of the modern bad faith tort in our brief, showing this is a foot-dragging case, not some of the other categorizations. We trace the history of the claims file discovery as it went through the prejudgment interest statute into the bad faith tort generally. And we see that the attorney-client privilege as it comes to the claim file, it's not just that it's a waiver of the privilege within the statute. As the Supreme Court said in the Squire-Sanders case, it never attaches in the first instance. Going back to the ancient roots of the privilege, the attorney-client privilege, it's unworthy, the claims file is unworthy of the protection of the attorney-client privilege in a bad faith case. It never attaches in the first instance. And the work product doctrine has, as we know in the Ohio version of it, has a good cause exception, meaning you don't get work product but for a good cause. And the Supreme Court said that that good cause requirement is categorically satisfied by the legislature's intent behind the prejudgment interest statute, where we get to bad faith from, which is to encourage and bring about settlements. So no attorney-client privilege, no work product doctrine. The only issue is what is the cutoff date for the claim file that is received. And we know that in a foot-dragging case versus a denial of coverage case, that the critical determination is relevance. Where will the relevant information to the insurer's decision-making be found? That was the rationale of Boone. Denial of coverage, it's up to the denial of coverage date, because that's where the information is going to be found to evaluate why did the insurer make a coverage decision. Foot-dragging case, it's going to be up until the benefits were paid, because that's where we're going to know why did they pay the benefits on this date. And Judge Kinsley, you took the words out of my mouth. I was going to hope that someone would ask me the question to make the exact point that you made, which is if Dr. Paley's report was indeed the smoking gun that caused them to jump from 38 to 150, then you would think that they would be happy to turn over the claim file and say, look, the letter that says, wow, Dr. Paley's report was really, really bad for us. We should pay the 150. You would think that that would be in there and that they would be happy to turn it over. And I think that's a critical, kind of more common sense approach to thinking about this case. But the case law in Uncles Bay has been unchallenged since it came out. The second district, we string cited all the cases that say that it's the right decision and the way to look at this case. Moreover, as we've said at the beginning here of my presentation, that this is actually the least offensive to the insurer version of the case that it could be, because the UIM case is completely resolved before the bad faith case has even arisen. The insurer, the appellant, talks a lot about anticipation of litigation. And I think it's important to note where that phrase has its place in this case, which is it's defining the rule for work product in Ohio. That's the narrow place where that exists. It's in 26B4, that documents, memoranda, et cetera, made in anticipation of litigation are work product, but the exception is good cause. And as I said earlier, good cause has been found to be categorically satisfied in these cases. I also wanted to address this idea of active litigation, which counsel mentioned. We're not, at the time that we were litigating the claim file, the active litigation, the UIM litigation was over. It was not active litigation. I know I've said that a few times, but just to make sure when we're thinking about this idea of active litigation, we weren't asking for their internal deliberations in the bad faith claim after we filed it. In other words, how are you defending this bad faith case? We weren't trying to discover that. That would be after the benefit payment date. So that's not an issue either. And I would just note too that in their brief, the big point was this idea of the chilling effect on insurers' ability to defend cases. On the one hand, all the arguments in the brief of my friend on the other side were really arguments addressed in Boone, even though it was a denial of coverage case. They said the underlying status of the claim in litigation or not is irrelevant because you can stay and sever the discovery, you can bifurcate and stay the discovery. And two, that to assume that there would be this chilling effect would be to assume that insurance companies and their attorneys would actually game the system in a way or violate their duty, was the way that the Boone court said, and not properly evaluate cases and not properly pay because they were afraid of bad faith later. So this is an old battle that's already been lost on the arguments that have been raised by my friend on the other side.
And can there be some carefully crafted protective orders in the event that there's, I don't know, some industry trade secrets about how insurance companies operate in the file? I mean, there's attorney's eyes only orders and things like that that could keep this very narrow if need be.
That's true as well, Judge. I would say that certainly getting back to the beginning of our discussion on the privilege law, if there's going to be sort of trade secret arguments made, I think that's almost a separate branch of issues than we're talking about here. And those issues have not been raised. If they were, I think we'd have to litigate that on the case law governing that.
Yes, we're speculating. We don't know what's in the file.
Right, exactly. But I think, yes, those are certainly separate issues that could be litigated on their own terms. So, yes, I think that Boone actually undercuts each argument that my friend on the other side has made here today in regards to the chilling effect. And with that, I'll submit for the court's questions. Any additional questions you may have.
Any other questions? Okay, thank you very much. Okay, you can come on up and you have 5 minutes.
Thank you, Your Honors. Privilege does not go away once a lawsuit ends. Privilege created during that lawsuit remains privileged, and just because a lawsuit settled does not mean that attorney-client communications that were exchanged during that lawsuit all of a sudden end.
Okay, I'm gonna interrupt you and go back to the privilege log. I understand that there was a privilege log for materials before, was it August?
There was a privilege log that was provided in advance of the April 26, 2023 hearing at the request of the judge. That privilege log did extend into the claim log or the claim materials after the lawsuit was filed.
Okay, but you do not know if that is part of the record?
I don't believe so. That was at the court's request provided to the court through their constable staff attorney person, and it was emailed directly to the court. And to counsel, I believe. I do believe it was shared with counsel.
Okay, thank you.
Yes. And there's a note made about prejudice, and this no prejudice to farmers by the fact that they're entitled to this privileged communication because the underlying lawsuit has been resolved.
Counsel, can I ask one follow-up question? You said it extended into the claim, the magic period.
Correct.
Did it cover the whole period?
It would have covered all the way up until the time in which the bad faith lawsuit would have been filed. Admittedly, Your Honor, I don't think there is anything that would have been in the file after the payment of settlement and then the bad faith lawsuit filed. So it may not have an end date that goes all the way up to that July.
I understand. There might not be any entries.
That's correct, Your Honor. It does. And I believe that there is, I don't know exactly the right way to word this, but maybe a bulk entry where it had the dates from after the lawsuit was filed to the date of settlement, that disputed period of time. And I think it had an entry just for claim file and privilege and communication. Attorney-client privilege and work product was the reason for that. And we never received an objection to our privilege log. And we had a deadline from the trial court as to when to provide it, along with the
Is that
supplemental
on the
briefing.
record?
The deadline for when we were
The court asked you to provide that. I'm just, it's obviously we can't consider things that are not on the record.
correct.
So
Yes.
I'm just wondering how we're going to find this information.
Yeah, and unfortunately, Your Honor, that particular request by the court was made at a status conference to help address the discovery dispute issues that was not on the record. So that particular request, as far as the timing, and that, no, there's no way for this court to get that information because it was not on the record.
Is it your position that it should have been part of the record? That privilege log that was then provided, should that have been part of the record?
No, Your Honor, I don't think that there's a requirement for me to file a privilege log with the clerk of courts to make it part of a record.
I didn't say it by you, I just said should have it been part of the record. I never said by you.
Thank you, Your Honor. In light of the court's questions, sure, that'd be nice. But whether they can anticipate that
In other words, you provided it to the court, right?
I did.
And it was, provided to opposing counsel, right?
That's my memory, yes, Your Honor.
It should have been made part of the record. Was it intended to be part of the record at that time?
It was clearly intended to address this discovery dispute, and since this is what we are here to address, then yes, Your Honor.
I mean, it's somewhere.
It is somewhere, yes.
It didn't dissipate.
No, that's correct.
Counsel, was anything from this window of time ever turned over? I'm assuming, because we've talked at least about Dr. Paley's report, maybe there are other documents that I'm not anticipating. Was anything ever turned over?
My memory is no, Your Honor. I don't believe we would have produced anything during that period of time in discovery in this case. Part of the reason, and I know that it's not necessarily getting to the question that you're intending to ask me, but we probably wouldn't have produced the plaintiff's medical records over again that were received in supplemental discovery, interrogatory responses. We probably did not produce that in discovery in this
But wouldn't it have been important to your position as to good faith to show when you received certain information and that you had it at a particular time?
Potentially, but at the same time, Your Honor, when you're looking at their complaint that they allege, they say that the bad faith was committed before the lawsuit was filed. It's important to note that, and that's why I wanted to get that in before my time ended. And I think that that's something that the court should look at. And I see my time is up.
And I just have I have another question.
Yes.
So my understanding up until literally right now has been that you're taking the position that the entire claims file is subject to the privileges that you've asserted.
That is correct.
And in fact, I believe you began your argument that way, that it's everything.
That is correct.
But now I'm understanding that there is a privilege log and that the privilege log may or may not correspond to everything in the file.
No, I believe it does say that. I believe there's an entry in there that says the entire claim file from these dates. That's on the privilege log that's not being produced.
I see. Thank you for clarifying that. That's very helpful. So
Okay.
the privilege log says the whole claims file for this time period.
For this time period. We produced everything before, but not during this disputed time period when the active litigation.
All right. So the privilege log does not say, for example, email on this day, letter on this day, document produced, memo produced on this day within that time window.
Maybe not that detailed, Your Honor. No, I don't believe so.
That's very helpful. Thank you.
Yeah. Thank you. Well, thank you, Your Honors. I greatly appreciate your time, and we would ask that you reverse the trial court's decision. Thank you.
Okay.
Thank you.
Thank you to both of you. We will get your decision out in a timely manner. And that concludes our arguments today. Thank you, everybody, for coming, and have a wonderful rest of your day.
Thank you.
All rise. The Court of Appeals, First Appellate District of Ohio is now